Time is just gone 9:35 a.m. as we continue with the show this morning. Now, we've heard about today, the 5th of August at 10 o'clock this morning, where the Constitutional Court will hear an application by the Women's Legal Center Trust to confirm an order of the Supreme Court of Appeal. Now, this order declared the Marriage Act of 1961, the Divorce Act of 1979, and certain provisions of the Divorce Act to be inconsistent with certain sections of the Constitution because they failed to recognize marriages solemnized in accordance with Sharia law. And we joined on the line this morning by Director of Women's Legal Center, Seehaam Samaai. Seehaam, Assalamu alaikum wa rahmatullahi wa barakatuh. Welcome to the show.
Assalamu alaikum to all of the listeners of Salam Media, and also shukran for having the Women's Legal Center.
Seehaam, just looking at what is about to take place today at 10 o'clock this morning, where the Constitutional Court will hear this application. And it's important for us to understand the context in which this application will be heard. And just to go back with regard to this order of the Supreme Court that the Women's Legal Center obviously made an application, just some background information that has led to what is about to take place today.
Yes, we all know that it's been a very long road for the Women's Legal Center and the women who have sought recognition of their marriages for the past 20 years. We all know that the Women's Legal Center started with this matter almost 20 years ago, but it launched in 2014. In 2018, the High Court actually declared and indicated that there is a positive obligation on the state to be able to enact legislation, and that there was a failure on the state in terms of the constitutional provisions of 7 and 9, dignity, equality, as well as 15, which is the broad right dealing with religious freedom. But we also know that the Constitutional Court, as the highest court in the country, will now finally have to decide on the issue of recognition and provide broad legal certainty on the various submissions that have been made, and that the state has a positive constitutional obligation to enact legislation. We also know that this matter is a confirmation of the Supreme Court of Appeal a decision, and there's various parties that have now come also into this particular matter, and the Commission for Gender Equality, the Human Rights Commission, as well as UPSA, have all applied to be amici within this particular matter. And so we will be hearing arguments from the state, from the Women's Legal Center, as well as some of the amici today.
Seehaam, we know that this has become a major talking point and also a major debating point from within the Muslim community regarding the consequences of recognizing the Muslim Marriages Bill. Now, one of the key issues here is with regards to regulation and regulating the consequences. And we know that Islam is obviously specific with regard to marriage. Sharia is specific with regard to divorce as well. Now, these are obviously sticky issues at this point in time. And we've seen in the last week or so, there has been so much coming through, particularly on social media, with a discussion after discussion and many, many debates on this topic. And just looking at it from your side and looking at the community in itself and some of the concerns that they have expressed.
Yes, the issue of recognition is critically important because there will be legal certainty in relation to the marriage, but it also attaches obligation. Because we know that our marriages are not recognized as full marriages, and it doesn't have the same consequences as civil, as well as civil marriages, whether or not it's in terms of the recognition of customary, or even in terms of the civil union, or even in terms of the Marriages Act. We don't have the same recognition, we don't have the same level of obligation after the dissolution or whether or not it's divorce or death. And so, also, in addition to that, to enact law to recognize that there's a recourse. From the dissolution, we all know that women contribute to the joint estate. And when that dissolution happens, their rights to housing and land and property is not really looked at as part of them contributing to that particular joint estate. And I think it's very important when it is recognized and regulated that the women will be able to take recourse to the courts to be able to ensure the enforcement of their orders. Whether, like I said before, whether or not it's in terms of the house, in terms of access, whether or not it's in terms of maintenance, whether or not it's post-maintenance, which is a spousal maintenance, those are all matters that women will be able to claim for.
Now, Seehaam, the key issue here is also about consistency, because this is exactly what this application is all about in terms of the Marriages Act and the Divorce Act being consistent with the Constitution. But again, the other argument, and particularly those that have expressed concerns with regards to this is, is a Sharia law, or will Sharia law be consistent with the constitution of the country, or will the constitution, override Sharia and go against some of the principles that Sharia, obviously, that goes against some of the Sharia principles?
Yes. Well, I mean, those are some of the challenges that have been brought out. We are of the opinion that there is compatibility, and it's not mutually exclusive, that the Constitution and Sharia is not compatible. This is about rights realization. It isn't doctrinal entanglement. It is broadly to be able to ensure that it's recognition and regulation so that women will be able to access their rights. And I think we need to be very clear around that this is a secular country. We live in a secular court. Sharia applies in a very particular way in secular countries where there are broader rights recognition, because we do have a freedom of religion, and we need to be able to understand that there is compatibility between the Sharia as well as the Constitution in relation to Muslim personal law. What we need to be able to look at is the actual interpretation of Sharia and how and the interpretation of Sharia in terms of the different quarters within our Muslim Ummah, our Muslim communities, and that it is a very conservative interpretation which comes out and says that the Sharia is not compatible with the Constitution. And I think that there's a lot of work and advocacy needs to be done by women's groups to be able to give a gendered lens to the interpretation of Sharia in relation to Muslim personal law.
Obviously, Seehaam, this is going to be the key issue. This is going to be the test at the end of the day in terms of the right to freedom of religion, and at the same time looking at legislation and how legislation looks at this right to freedom of religion.
Yes, but we also need to know that, I mean, fundamental to Islam is also equality, equity, and dignity, and be able to interpret Islam in a manner which is consistent both with Sharia and also to ensure that Muslim women access their rights, which is provided for also in the Sharia. The courts need to be able to be seen as a legislative framework to be able to ensure enforcement, because we all know that the ulama and those institutions that are doing divorces and they deal with estates, etc., they don't have enforcement powers, and we need to ensure that women have proper recourse to the state, to the courts, through the courts, to be able to ensure that their rights are recognized. Can I just
obviously, it's not so straightforward, Seehaam. As you mentioned, enforcement is critical, and we know that there are many people that are shirking the responsibility when it comes to situations like these, particularly when there are divorces and people trying to basically get away from the meeting their obligations. So that is important, I think, from an enforcement perspective and who has the power to enforce. Now, I've seen a comment that has come through on my screen right now saying that Sharia law is Sharia law, whether you live in a Muslim country or not.
Yes, Sharia law is Sharia law, but I mean, we also understand that the underlying interpretation when it comes to a broad framework of how Sharia is interpreted. And we need to understand that these qualities of equality and dignity all situate within Sharia in terms of interpretation. It is not that easy, but it's very easy for men who have historically benefited because of the non-recognition and non-recognition of our marriages. At the end of the day, that benefit needs to be able to be looked at in terms of how we can ensure that there's broader recognition for women in terms of what they can access. It is so difficult out there for women who at the end of the day have given 25 to 30 years of their marriage and to be able to walk away with nothing due to the lack of recognition of their marriages. It is unacceptable both in terms of our constitution, but I would also say it is not allowed in terms of the Sharia to be able to leave women and children destitute after the divorce and the dissolution of the marriage. And so I do think that ulama need to really come together to be able to ensure that there's uniformity in terms of the interpretation of Sharia and how women can be protected at the end of the day.
Seehaam, and just finally looking at this application now, I know previously in the High Court, the Women's Legal Center had out the court to direct the President and Cabinet to prepare, to initiate, to enact and bring into operation legislation providing for the recognition, and that was all within 12 months. Now let's just talk about the timing of all of this, and obviously today's application, how is that likely to play out in terms of the timelines that have been set?
Yes. Well, I think it's a very important question that you're asking, which is why one of the relief that the Women's Legal Center is asking is for interim relief, because we know that there is law reform processes which is currently before the state. The state has the Department of Home Affairs.
If you could just move around.
Sorry, the Department of Home Affairs has published the green paper on marriages, and then secondly, we do have the single marriages discussion paper that was issued by the South African Law Reform Commission. But we all know that in all likelihood, we will not only see this law by 2024, based on the different law reform processes. So in the interim period, there needs to be remedies for Muslim women who had their marriages end in death or divorce. Today, we wanted to ensure that the Constitutional Court also understands the importance of the interim relief pending the legislation being enacted, and that the court understands that it must include as many women as possible, because we should not leave any women suffering because of the injustices, and also we should not exclude them. We need to acknowledge that South Africa is made up of diverse families, and the state has an obligation to ensure that it recognizes the diversity and promotes the rights of the most vulnerable. So even though we have these law reform processes, we know currently women are still being disadvantaged because of the non-recognition of their marriages.
Well, Seehaam, let's see what develops today. But as always, we thank you. We say Jazakallah to you for your time with us this morning here on Salam Media. We wish you all the best, inshallah. Assalamu alaikum.
Assalamu alaikum.
Seehaam Samaai, Director of Women's Legal Center, with us this morning, and these are obviously interesting times, interesting developments, and let's see what comes out of this application that has been made by the Women's Legal Center Trust this morning at the Constitutional Court. The time is just gone 9:49 a.m. We're going to go for a quick